Good afternoon, ladies and gentlemen. My name is Omwe Mazenge, and on behalf of ACE Litigator, welcome to our webinar today. Apologies, we started 2 minutes late. We had a bit of a technical hitch. Now, a few housekeeping rules just before we start. The meeting is being recorded, and this is purely for educational purposes. We shall share the recording after the webinar. The presentation will take about 40 minutes, and thereafter we shall enter into a Q&A session. So you can make use of the chat box or the Q&A features. If you'd wish to ask your question orally, you can raise your hand at the end of the presentation, and our IT guys will assist you. We are also live on our social media pages. You can find us on Twitter, Facebook, and LinkedIn, and the name is ACE Litigator. Well, our speakers for today are both advocates of the High Court of Kenya. We have Mr. Ambrose Waigwa, who is a senior associate at CM Advocates with over 5 years of experience representing various bands of clients in litigation matters, both in courts and in tribunals. We have Ms. Susan Mwango, who is equally a litigation lawyer at CM Advocates, LLP. Now, presentation for today, as you've seen in our posters, we're going to address the importance of well-drafted pleadings in effective trial advocacy. We shall be looking at exactly what pleadings are, the types of pleadings, the importance of well-drafted pleadings, the defective pleadings, and exactly how you can the way you can cure defective pleadings. Now, we have seen a rise in judicial pronouncements on exactly what bad pleadings are. In fact, recently, in a decision by Justice Dr. Fred Nyagaka, he termed certain pleadings to be so defective, such that in his view, he thought that such pleadings should even be used in law schools to exactly explain what bad pleadings are and to teach law students exactly what pleadings should be like. And so I just want you to explain to us, do you think this is a cause to worry, especially among the legal profession, the fact that we're getting a lot of judicial pronouncements on bad pleadings that are placed before courts?
Thank you very much, Wamoyo, for that introduction and the question. I think it is really a cause to worry when pleadings are done the way we have seen them being done nowadays. There is a trend where pleadings have become so badly done that court pronouncements have been condemning the litigants who have done the pleadings and really made a huge deal out of it. It's worrisome because it wastes a lot of judicial time. It means parties cannot litigate their issues well. It leads to increased costs, and definitely it leads to a lack of trust in the judicial system by litigants who think that the courts have probably overlooked their issues, yet it is them who have drafted the pleadings badly. Thank you.
Thank you, Wamoyo, again for that presentation. Of course, it's a cause to worry, and especially when we have judicial officers, in this case, Dr. Nyagaka, expressing such scathing statements. It is a cause to worry. It is a cause to worry.
Okay, recently the legal profession has we saw some advocates take documents in courts in a lorry, and I know for those of us who are on Twitter, there was a lot of memes surrounding that. Now, I understand that pleadings fall under such documentation. So, Susan, how would you define exactly what are pleadings?
I will give the textbook definition of what pleadings are, and that is to say they are written statements of facts that are drawn up and filed in court. But when you're looking to describe from what perspective? From the claimant's perspective, pleadings are the way in which they express their case. what claim do they have against the opposing party or the defendant or the respondent? What case do they have? Then when you're looking at now the respondents, on the respondent's point of view, here, this is what response does he have, or what defense does he have to the claims that have been raised by the claimant? And when you're looking at now the bench, pleadings are to them, what issues have this court, have these parties brought before us to determine? So when you're looking at pleadings, I think that is how I can define pleadings in a very practical way.
I like how you've defined pleadings from the different perspective, from a claimant, a respondent, and the court. Now, are pleadings just one standard document, or do we have different types of pleadings?
Of course, there are various kinds of pleadings, and what that will determine is which forum is the litigant in, and which matter, or what is the nature of the matter that the litigant is presenting. So that for these categories, there are various kinds of pleadings for that. So that there are claims, there are originating summons. When you're doing applications, there are motions, there are chamber summons, depending on the nature of the matter, and of course also depending on which forum you are in.
Thank you for that, Susan. I'll pose the next question to Ambrose. What would you say is the importance of pleadings? I mean, if I have a case against you, would it be sufficient for me to write a letter to court? Or even considering that we are in the age where people have embraced social media and we have a lot of our judges on social media, can I just go to a judge's Twitter inbox and just inbox them my grievances? Or exactly why is it important to have pleadings in the administration of justice?
You cannot do that for the reason that, number one, pleadings creates a certain degree of certainty. That is why we need properly drafted pleadings presented in court. For instance, you will have to define who the parties are and what their relationship to you, the aggrieved party, is. Take, for instance, a plaintiff. You'll have to state who the first defendant is, who the second defendant is, how they come into your case, and probably their legal standing in the country as well, as far as you are concerned, and all those things. That can only be done in pleadings. Secondly, after introducing the parties, the pleadings also introduce the issues in a very succinct and chronological manner. That again cannot be done haphazardly without being well drafted, because it would mean you would confuse both the court and the adverse party. Now, remember, we are in an adversarial system where justice is usually done according to a system where the court is not going to delve into asking questions, what is known as inquisitorial. The court rather allows the litigants to put their cases forth by having the facts written down so that you are not surprising the other party with facts. So they form an integral part of any dispute resolution mechanism, especially in Kenya, because they give parties an opportunity to respond to the issues which have been put forth by the opposing side. And they also allow the court to delve into the issues between the parties in a clear and concise manner. So that is why the pleadings are important in this country.
Now, do we have any laws that govern pleadings? Exactly what pleadings should be and how pleadings should look like?
Of course, there are laws that govern what pleadings are, which pleadings should be used in what forums. Of course, we have to start with the Constitution when we are discussing laws that govern pleadings. And the Constitution at 159, at Article 159, Subarticle 2, tells that when the court is dispensing justice, it should not pay undue regard to technicalities and procedure. So that is the first guide that we get from the law that tells us, that governs how the structure of pleadings and how pleadings should look like. We also have laws such as the Civil Procedure Act and the subsequent civil procedural rules. We also have the Criminal Procedure Code when we are talking about criminal litigation that guides pleadings in that sense. We have, so there are laws that govern. You will not just go blindly to a court forum. There are laws and procedure that guide how you structure and how you present the pleadings.
Recently, we had a one-paged pleading that was going around in our circles as legal professionals. And the pleading was a one-sentenced pleading saying that the property belongs to me. I have all the legal documents. Now, considering that we are looking at what well-drafted pleadings are and exactly how they contribute, in trial advocacy and the administration of justice, Ambrose, what would you say is, the principles that are accepted when it comes to pleadings? What should be in pleadings and what should not be in your pleadings?
So I think as we get Ambrose, the question you ask is what should be and what should not be in your pleading? I think when we are talking about the civil procedure rules, Order 2 of the civil procedures rules gives us a guideline of what should be there and what should not be there. For instance, when we look at Order 2, we will find guidance such that state material facts. State facts do not state evidence. If you are presenting numbers, let them be in figures. So there's various guidance that we get from the law, from the civil procedure rule when we are in civil court, that tell us exactly what should be there. So the question of what material facts and what is immaterial will be answered as we go forward. But I think what I can say is the law gives guidance to litigants. The law gives guidance to court users as they draft their pleadings.
Yes, Wamoyo, I am now back.
Welcome back.
Yes, so I was saying that for pleadings, you have to have a very clear way of doing things. We normally start with the title, which shows which court the matter has been filed in. It then goes to the parties, which will definitely be important because you cannot have a case against nobody or a case by nobody against everybody. You will have to show who exactly the parties are. And then from there, you will go to description of the parties. And now from there, we go to the facts of the case. That is the issues which gave rise to the dispute. You will conclude and you will have your prayers and you sign off. Now, it is very important to note, just like Susan has stated, that we do not plead the law in pleadings. Neither do we plead arguments or opinions or hearsay. Now, for instance, when you state, like the litigant you just described, who stated that the property belongs to me, now that can be said to constitute a bare allegation, which will be struck out for being scandalous and also for being unfounded. Now, you cannot, again, due to the emotional nature of suits, attack the integrity of parties or be speculative in a pleading. That, again, will not see the light of the day. It will subject you to costs and it may be struck out anytime. Now, given that you have brought your matter to court, your case should be left to the court to determine. You should not come to conclusions of evidence or conclusions of the law in your pleadings. You are supposed to state the facts that gave rise to the dispute in a very simple and clear way without going into any conclusions that would make it difficult for the court to sift through to see what is really the issue and what is really your opinion. Case in point is, say you have been slapped by somebody. You are supposed to state in your pleadings that on a certain date, at a certain time, at a certain place, you were slapped. Now, it is not for you to state that that slapping constituted aggravated assault, because that is a judicial conclusion and that you leave to the court. So once you state that, you move on and you say maybe you went to hospital, you were treated, and you incurred such and such costs. So that is the importance of really having the pleadings in place, as opposed to doing things haphazardly, writing letters, or even going to judges' inboxes. Thank you.
Well, thank you for that, Bruce. Well, recently we had a decision by one of the judges saying that sometimes pleadings are so poorly drafted that it's even hard for the court to even know exactly what you're seeking before them. And we have this common phrase among our judges and even in a lot of pronouncements saying that courts are bound by the pleadings that you place before court. Now, what exactly is the duty of the court, and even the duty, your duty as a claimant or as a respondent when it comes to placing pleadings in courts?
Thank you.
Okay. Now, perhaps I'll give the duty. What duty does a party in litigation have when it comes to drafting pleadings and presenting their case in court? So the litigant has to present their case in a concise manner. The litigant has to, as Ambrose says, has to present the facts properly in such a way that will be able, the court, to determine what exactly is the issue that is before the court for determination. So I will say that is the duty that a litigant has.
And for the court, the court has a duty to analyze the pleadings presented before it and to find out what the issues are and to come to a conclusion based on the law. So that will be the duty of the court, to inspect the pleadings, to analyze the issues, and to assist parties come to a conclusion, and that is by rendering judgment.
Well, thank you for that, Susan and Ambrose. Now, you've told us everything there is about good pleadings. Now, what happens, because I understand that sometimes maybe someone does not have the ability to hire legal counsel. What happens when they put defective pleadings in court? Does it mean that that is the end of the journey for them? Does it mean that the court will look at the pleadings, strike them out, and that is it for them? They cannot get justice before a court. Exactly, is there a remedy to any such defects?
There are two ways to go about that. The first way is that parties are allowed to amend their pleadings if the case has not been closed for normal civil cases, and where the case has been closed, you can apply for leave from the court to amend your pleadings, and the court will normally give you leeway to amend your pleadings. However, this comes with a rider. If the pleadings are so hopelessly done, the court will normally strike them out, because it will not allow you to introduce new cause of action. It will not allow you, for instance, to try and use Article 159 to cure incurable defects, for instance, things to do with jurisdiction, or even when it brings hardship to the other party. So ordinarily, there is that leeway to amend pleadings, but it is not always a given. It is strict, and it has got timelines as well.
Well, thank you for that. I think I'll pose this to Susan now. What you may or not, you may not be given an opportunity probably to amend your pleadings, or someone may not even may not be even aware of the fact that they can amend their pleadings before court. What is the likely effect of having such defective pleadings in court?
So, of course, the effects of having defective pleadings is that, number one, even as Ambrose is talking about the process of amending pleadings, you have to know that amending of pleadings, there is a procedure for amending pleadings, so that after the close of pleadings, then you have to make an application to amend the pleadings. That application has to be heard, and then you will be allowed to amend your pleadings and now bring proper pleadings before the court. Of course, there is a cost to that, and the cost is about the extended judicial time that has been expended. The case could have been probably had and dispensed with within 5 months, but now this extra time has caused delay. So there is a delay, and also there is a cost that comes with amending pleadings, because again, you're making an application. There is a court fee that is attached also with that. So you can see the effects of badly drawn pleadings, and how extensive this costs is, and how extensive the effects are in this way. And we know with the backlog of cases in court, the court is always advising litigants to do their best to ensure that they do not create the problem of backlog. So that is the effect of badly drafted pleadings in that way. Also, we can talk about, when you're talking about questions of the rule of law and how justice should be dispensed equally to everyone, and the law should affect everyone in equal way. You'll find that when your pleadings are so badly drafted that the court cannot pick out the issues properly. And also, if you are a claimant, now your case is so badly drafted that the defendant and the opposing party is not able to pick out exactly what the case against them is about. You see that, therefore, it is difficult even to apply the same rules to everyone, so that there will be a problem even in the final dispensation of justice.
If I remember my civil procedure class, we understand from the law, the Constitution, and even the Civil Procedure Act, matters have to be determined in a timely and a cost-effective manner. Now, and it is even our duty as litigants, as we are approaching courts, to ensure that we assist the court in that. Now, what would your advice be to anyone who probably has defective pleadings in court? I think I'll pose that to Ambrose.
Anybody faced with defective pleadings should do the following. If you are the person who has presented the pleadings, you should apply for leave to amend your pleadings and get a proper legal drafter to draft the pleadings for you. That could be persons such as a litigator or a counsel of your choice if you can afford one. 2, if you are the defendant, or if you are on the other side, you should immediately apply to strike out that matter, and not necessarily because you want to ride on the technicalities, but also because it will give you a chance, or rather the defective pleadings do not give you a chance to access justice the right way. So you should look at it from whichever side you are standing on. So if you are on the side of the litigant, you apply to amend, and if you are on the other side, you apply to strike out the suit. Omoyo, I can also see there is somebody who has raised their hand. I think we can allow them to address us once we are done with this session. I understand we are not far from getting done.
Thank you for that, Ambrose. Now, back to the Constitution of Kenya, you said that the Constitution is one of the laws that governs exactly how pleadings should be, Susan. Now, from Article 159, it says that justice shall be done to all, without regard to technical, those technical, technicalities. Now, exactly, do you think Article 159 cures the issue of defective pleadings, or exactly where do we stand when it comes to that?
I will say, even as we are answering this question, if Article 159 to cures defective justice, we should, as I had said previously, address our minds to what are the effects of badly drafted pleading. So we will go there and say, even though Article 59 tells us and tells litigants and I mean advises judicial officers to be liberal in the way they are interpreting the law in terms of poorly drafted pleadings. I love what Justice Kiage once said, and I will quote him directly. In Nicholas Kipruto Arap Koril Salat versus IBC and 6 others, this is a 2013 case, Justice Kiage states that I am not in the least persuaded that Article 159 of the Constitution and the Oxygen Principles, which both command courts to seek to do substantial justice in an efficient, proportionate, and cost-effective manner, and to eschew defeatist technicalities, were ever meant to aid in the overthrow or destruction of rules of procedure and to create an anarchical free-for-all in the administration of justice. So that procedure is there to guide even the substance, and procedure is part, the following of procedure guides even the judicial officers in exercising justice and substantive justice. So the short answer to that question is no. It's 159.2, even as we have a remedy and a cure, and we can always fall back to 159.2 and Civil Procedure Act Section 1A. We should strive to ensure that we always draft proper pleadings, because the costs of not drafting properly, the cost of not drafting proper pleadings is very expensive.
Now, Ambrose, it's very common to hear the word frivolous, scandalous, vexatious. You quoted it yourself here. We even have a Vexatious Proceedings Act in Kenya. I mean, what do these words mean to the ordinary person? I'm sure in the legal circles, we hear these words a lot. So what do these words mean? And exactly why would a court say that probably your suit is frivolous and that it's scandalous or that it's vexatious? And what test has to be made for someone to even be declared as a vexatious litigant?
Thank you. For a vexatious litigant, that's an entirely different type of way to look at it. I will explain who a vexatious litigant is before I explain what scandalous, frivolous, and vexatious pleadings are. Now, a vexatious litigant is a litigant who is used to suing for the sake of suing. There are litigants who will sue you, let's say, on a loan agreement. They will sue you for maybe destroying the collateral. Tomorrow they will come and sue you for increasing rates on the loan. The next day they will come and sue you for induplam. Then after that they will appeal. Then they will sue you for something entirely different, also related to the loan. So it reaches a point when the suits are so many related to the same subject matter and between the same parties that the courts declare that person vexatious litigant. Now, under the Vexatious Proceedings Act, that person who is aggrieved by this litigant who keeps on suing them over the same subject matter in different ways or bringing different grievances is supposed to apply to the AG, who will now file the application to court for the person to be declared as a vexatious litigant. Once a person is declared as a vexatious litigant, you can only file suit with leave of court. That is to mean any other time you are aggrieved, you have to request for permission from court to file suit against any person. So that is for vexatious litigant. Now, when it comes to pleadings, Order 2, Rule 15 gives certain criteria on what may lead to striking out of pleadings. It states that when the pleadings are an abuse of court process, they will be struck out. When the pleadings are scandalous, vexatious, and frivolous, they will be struck out. Now, a document which demonstrates a complete absence of material facts will be declared to be frivolous and vexatious. Vexatious means it tends to annoy. If, again, your document is found to be irrelevant, argumentative, or basically with a lot of pomp and color for nothing, it will be struck out as being scandalous. We have seen previously a counsel who has drafted pleadings referring to an unborn child. It was something to do with the rights of an unborn child, and they delved into the act which led to this unborn child being conceived. Now, such pleading, in as much as we are not aware whether it was declared scandalous or not, may be held to be scandalous because it surpasses certain bounds of civility and morality. So now those are what courts will not entertain at all, and hence now they came with the three fancy words: scandalous, frivolous, and vexatious. So basically, anything that is unfounded, anything which is inflammatory, anything which attacks the integrity of the party or a party or a court, anything which is immaterial, and anything which is baseless will be found to be scandalous and frivolous. Thank you.
Now, Ambrose, you mentioned about material facts. Now, in a pleading, what exactly is material and what exactly is immaterial?
Now, material facts are those facts which are relevant to the matter before the court. Now, those are the material facts. And that will mean that immaterial facts are the opposite. That is, matters which are not relevant at all before the court. Again, by way of example, if you are, it's an employment matter, and you want to plead assault, the assault may not, unless the question, the employment question revolves around that assault, the assault may not be material to the employment issue. Or if it is let's say a tort issue, and you want to bring in hearsay, that may not be relevant to the issues. So that becomes an immaterial fact. So material facts are the facts that are strictly relevant for the case before the court.
I'll pose this question to Susan. I have to admit, even as a junior advocate, that I've not come across some of the pleadings that you've talked about. Do you think there is probably a lack of, maybe a database that could guide even young lawyers and even people who are, representing themselves in court to avoid this whole issue of having badly or rather poorly drafted pleadings in courts?
I think there is a database, and the database that most litigants have is that when you're faced with, if you have a case and you want to draft pleadings and you want to seek guidance from somewhere, the database most probably is the contacts on your phone. You start calling other advocates, other litigants, and asking them to give you perhaps a precedent that would act for you as a guide, even as you draft your pleadings. So I think that is the database that we are working with in this space that we find ourselves in as litigants. But as litigator also presents a forum, they have well-curated precedents on various aspects of the law. that can guide any litigant in whatever matter it is that they are faced with. So you can go to ACE Litigator, you can log in, you can sign up at our website, and you can actually request for a database just to guide you even as you are drafting precedents for your case. So if we're talking about database, ACE Litigator provides that kind of database as one of its kind product. But the database that you most deal with for us is your fellow litigants. You ask them for precedents depending on which matter you are litigating on.
Well, thank you for that, Susan. And I think my key takeaway, or maybe we'll take comments from other people to understand exactly what their takeaways are, but pleadings are really, really important in the administration of justice. And just to even, Ambrose mentioned something about, giving the other person an opportunity to even respond. So it also gives that fairness when it comes to, the civil procedure. And I think at this juncture, we are going to take questions. Ambrose had mentioned there's someone who had their hand raised. So the technical guys can probably assist us in unmuting them. Caleb Obwara. I don't know if the IT guys can assist us in unmuting him. Caleb, can you hear us? Or you can drop your question in the chat box or the Q&A box. Brian Pareno, loving the presentation so far. Thank you, Brian, for joining us. Well, there seems to be no questions in the Q&A box. I'll assume that the speakers made a very clear presentation. Ivan Kiru is asking, kindly clarify on the issue of pleadings not containing evidence, because most do, especially those alleging fraud, breach, etc. I think, Ambrose, you can take that.
Yes, and now on the issue of pleadings containing evidence, the rules are very clear, especially the civil procedure rules. The only rules which allow facts, law, and evidence to be pleaded are the rules of the Employment and Labor Relations Code only. So that is an example of bad drafting, which has so far been allowed to happen in the judiciary, and it is so unfortunate because the rules are very clear. They state that parties should only present material facts and nothing but the facts. No arguments, no opinions, no law, no conventions, and no evidence in the main body of the pleadings. So that is basically the short answer to the question.
Thank you for that, Ambrose. I like that you've now gone into the Employment and Labor Relations Code Act, and allow me to ask, we have the Small Claims Act that just came in recently, or rather they started running their operations recently, and we've seen that they have specific forms that they use when it comes to presenting your cases in court, and considering that this is the kind of court that you can actually go as a lay person and represent yourself, what level, how much are these procedures really followed in these courts? Is there space for someone to even probably even handwrite their case, present it in court, and be heard?
The rules allow for some latitude in terms of curating your problem to fit into the forms, because they allow you to amend or fix the case as if we can use those words, to fix the case to fit into the forms. But given the nature of the small claims court, it is not intended to have those long drawn arguments or copious amounts of documents. It's supposed to make the process simpler. And that is why they have provided those forms as a guideline, so that you state your case in a nutshell. But the rules allow you to deviate just a little bit, but not much. Again, you also note for those who have filed cases whose value is below 1 million in the small, in the lower court, that is, those cases will be transmitted to the small claims court with the pleadings being the way they are. So you will find you have a plaint in the small claims court, not that that is where it was supposed to be, but I believe in the interest of Article 159, then it will be taken there and it will not be struck out. But ordinarily, we should follow the rules, which is outline your case in the simplest way possible using the forms provided. Sorry, Wamoyo, you are muted.
Thank you for that, Ambrose. We have a question by Wendy Ngunga. She's asking, please explain what jurisdiction is and how it relates to pleadings. I think I'll give that to Susan.
I think when you're talking about jurisdiction, it's the extent within which a judicial officer can exercise their authority. So that when you're talking about jurisdictions, there are questions of pecuniary jurisdiction, which governs the extent within which it's not the monetary value within which a judicial officer can determine a case. So that if the pecuniary jurisdiction of a court is 5 million, that means they can only address their minds to cases that fall within that threshold. And when we also have, we can also talk about, when we're talking about jurisdiction and the extent of judicial authority, we also address our minds to the locality, so that if a case arises within a certain area, the case arises in Nakuru, you cannot bring it in say Mombasa, for instance, so that the extent of that judicial officer, the extent of that court has certain limits. So when we're talking about jurisdiction, we are talking about the extent within which a judicial officer can exercise the authority, and jurisdiction is well spelled out in the law. We know for these cases, they go to this court, and for these cases, they go to this court.
Thank you, Susan. I think that's, at least we know what jurisdiction is. There's a joke among legal professions that whenever you ask people what jurisdiction is, they say jurisdiction is everything. So at least now we know what jurisdiction is. Thank you, Wendy, for that question. We have a question by Gashoka Karanja. He's asking, does this apply to election petitions going by what was filed in the recently concluded presidential election petitions? I'd assume you're referring to defective pleadings. Maybe Ambrose can take that.
Thank you. I will respond to that alongside a question by Mr. Obila Ogada, where he asks, what about the part for constitutional petitions, where the rules allow the petitioner to show the contravened constitutional and statutory provisions? Would that amount to pleading the law and drawing your conclusions, which, as per your arguments, are not to be contained in the pleadings? Now, for petitions, and specifically election petitions and constitutional petitions, a leeway is allowed because of their nature. Even when you look at the Mutunga rules, for you to plead the case, that is to plead your facts, and to plead which specific provision has been breached, to prevent litigants from constitutionalizing every matter. So it is allowed. There is a multitude of authorities on that area, starting from Anarita Karemi Njero, which says that you should pinpoint the specific provision of the law that has been breached, or rather the specific provision of the Constitution that has been breached. So for those, that is also another exception. So those ones are allowed. So again, it goes to the specific rules of each court. You note that, like now, for instance, we've talked about the constitutional petitions. Those ones are guided by what is called the Mutunga rules. Those ones will allow it. The Employment and Labor Relations Court rules will allow it. The civil procedure rules will not allow it. Now, it behooves litigants before filing cases to go through the rules of each court and specifically find out what is allowed in each in the courts, because it is not it does not necessarily cut across, but those are the exceptions rather than the norm. The norm is do not plead law, do not plead arguments, and do not plead evidence.
Thank you, Ambrose. Now, Susan, you told us and explained to us the different types of pleadings that we have. Now, Josh Okoth is asking, what is the difference between a plaint and a petition? And when do you use a notice of motion?
So when you talk about a plaint, and I think the difference comes really in what nature. What is the nature of your dispute? What is the nature of the case that you're bringing before court? And that really is the distinguishing feature when you're talking about are you using a plaint or are you using a petition? So it's what is the nature of your cause? So that you will find plaints mostly being used in civil disputes. Civil disputes, and petitions usually when you're claiming a right. So when you're claiming a right, for example, your right has been violated, you will file a petition to the constitutional courts. So the nature of what a plaint is and the difference of what is a plaint and what is a petition comes really in the nature of your case and which court you are approaching. I don't know if the other part of the question, if you can kindly.
Well, Josh is asking, when do you use a notice of motion?
So a notice of motion, it's an application. So you might have already filed a plaint and you might have started or initiated proceedings with court, but in the meantime, or certain issues arise within the suit and you need to make certain applications for court to grant certain orders. For instance, I had mentioned a good example we had when we were talking about amending pleadings. You have, when you're amending pleadings, you have to make an application for the court to allow you do that. So you will go by way of an application and several other applications that you might want to make. You might want to seek interim orders. So if you're seeking interim orders, as the suit is going on, but there's something that you want the court to do for you in the meantime, you will file applications as a way of asking the court to grant you certain orders, even as you're going along with the suit and your initial cost that you had filed.
Well, thank you for that. You also mentioned when you explained the different types of summons, there is chamber summons, there are originating summons. Frida Wangui is asking, when do you use originating summons? I mean, why can't you just file a plaint in court?
Okay, you cannot just file a plaint in court because, again, we said the structuring of pleadings is governed by law. So when you're looking at the civil procedure rules, and specifically I'm answering the question about originating summons, Order 37 of the civil procedure rules particularly outlines the disputes, the matters, the instances within which a litigant should use originating summons, so that you're not just doing it out of a whim that you have decided you want to do. There's rules, there's procedure that governs why you have used an originating summon as opposed to a plaint. So for certain matters, the civil procedure rules dictates that you go by way of an originating summon and not a plaint. And similarly for application, the law equally dictates when applications. So ordinarily you would use notice of motion to bring your application, but the law also particularly states that for certain applications, then you would have to go by way of chamber summons. So the short answer is that the reasoning is informed by the law.
Well, I'll pose this last question to Ambrose just before we wind up. I've also been interested in knowing, are submissions pleadings? Exactly what's the place of submissions in the legal process?
Now, submissions are usually replications of facts, evidence, and the law for the court to consider and make a final determination once either a hearing has been made or once arguments have been put forward through an application. So those are usually the submissions. Parties can decide to appear in court and highlight the submissions orally, or they can just draft them and give them to the court for the court to consider and make a considered determination. So those are the submissions. They are not pleadings in the way we have been talking about pleadings today.
Well, thank you. Now, Ambrose, Susan mentioned something that we all have a database when it comes to, getting pleadings. And she mentioned that we have contacts. And I do agree with that, because I think one of the things that we were taught even in the early stages of, practicing law is that your contacts are very important. The networks that you make are very important to you. However, considering that you have judicial decisions saying that some advocates themselves are taking bad pleadings in court, you could have someone who sends your pleading and it ends up being, being the subject of a ruling. Exactly what is the solution to that, to ensure that we have a particular standard when it comes to pleadings that are being placed in court? Ambrose, I think you're muted.
Now, the solutions lie with the litigants themselves, and they are many. It's not a one-fit-all solution. Now, the first solution is, if you are a literate litigant, then you may want to draft the pleadings by yourself. Now, to ensure that you present your pleadings in a manner that will not be acrimonious, or in a manner that the court will not find fault with your pleadings, you are highly advised to get a lawyer or to get templates for your pleadings from organizations which give you such templates, or to get advocates to draft for you just for the sake of drafting, and not necessarily that you will retain them for the case. We have so many lawyers around. There is usually a joke going around that if you go to Jevanji and you throw a stone, you might hit a lawyer. So just get a lawyer to draft for you good pleadings, and you'll be good to go. Now, for the lawyers, thorough research is very important. Reading the rules of the specific court is very important. One day, our senior, Steve Ogola, told us that we should read at least 10 judgments a day. You can add one more, and you can read at least 11, so that you are thoroughly acquainted with the new developments in the law and with the practice. Doing a lot of those pleadings as well will be an added advantage to you. You cannot perfect what you do not do. You cannot, again, practice on the day you are supposed to do the pleadings. You cannot start your client's case. You cannot practice with your client's case. You have to ensure that the bull is fattened before the market day. Again, being time sensitive, we have seen litigants preparing pleadings the last minute. And as you know, proper prior preparation prevents panic. So if you prepare pleadings the last minute, you are bound to panic, you are bound to miss out things, you are bound to overlook the rules of procedure, and basically you are bound to come up with very shoddy pleadings. So always do your pleadings in time. Don't go to court, or rather don't rush to do your pleadings at the 11th hour. Now, also ensure that the facts you present to court are relevant. There is sometimes cases which are brought to court which should not have seen the light of the day. Sometimes clients are aggrieved, but what they are aggrieved with is not something which is presentable in court. So for such clients, just advise them from the onset that they do not have a case other than draft embarrassing pleadings. And also look into other ways the matter can be solved even before embarking on drafting. Now, lastly, ensure you have all the relevant facts before you start drafting. We have seen advocates who file pleadings on a piecemeal. They litigate on a piecemeal. Today, an advocate will file a plaint which is not accompanied by the list of witnesses, a list of documents, and the witness statements and all those things. Then tomorrow they will file a list of witnesses, which is not accompanied by anything. 3 months down the line, they will file another document. That makes the court record very untidy. It increases the time for litigation, and it is definitely costly, and it looks bad for the profession. Now, the other thing which advocates must really avoid is imposing templates on every, say, problem without necessarily adjusting it to fit into the issue. Sometimes you read pleadings and you really wonder why the advocate just imposed the pleadings on the party without really looking whether the pleadings fit. That is a show of laziness. When you have a template, it's supposed to be a mere guide and not necessarily something to be taken word for word. So that is something else which we should avoid as litigants. So those are the solutions. There is no one major solution which can fit all those issues, but really all of them taken together will lead to better pleadings, will lead to expedited justice, and will lead to even enjoyable practice. Thank you.
Well, thank you for that, Bruce. I don't know how I'll slot in the time to be reading 11 judgments every day, but I think it's a practice that we should all probably, take up, and especially in our young years. And I think that's where, platforms such as Ace Litigator come in. Ace Litigator, you can visit Ace Litigator's website. It is an online platform that is run by legal professionals, and they provide high quality legal documents, which include pleadings, which are tailor-made depending on the issues that you have, considering that our speakers today have really said that pleadings, and especially while you're presenting a case in court, it ought to be, based on material facts. You're not pleading the law, you're pleading facts. So you can visit their website. It's acelitigator.com. Since we do not have any more questions and that we are way past 5, that will mark the end of our presentation. Thank you to everyone who's joined us. It's been a pleasure. Thank you, Ambrose and Susan, for gracing our screens today and taking us back to our civil procedure classes. You can find Ace Litigator at I&M Bank House. Our social medias are on Twitter, Facebook, Instagram, and LinkedIn is Ace Litigator. Thank you for joining us and have a wonderful evening.